morning, Advocate van der Westhuizen.
Good morning, CJ.
Is it fair to assume that you're not related to my colleague Johan van der Westhuizen?
I would have liked to have said yes, but no.
Okay. You've been in the profession for a long time. Maybe let's start with your role as an advocate. For how many years were you junior counsel?
32 years at the bar, and I'm 8 years a silk, so roughly about 25 years, I would have thought.
What took you so long to be silk?
Probably because I was too humble and thought I need some more experience before taking on greater responsibilities.
Yes. And your areas of focus were, particularly as a silk?
Particularly as a silk was intellectual property, although I did other fields too, mainly in the commercial area.
Did you study
in that? It was not by choice
yes.
in the intellectual property. I was, when I started, I was aiming to be a great criminal lawyer, but it did not work that way. One cannot always choose your field of expertise.
But how did you get into intellectual property? Did you pursue studies in that area first, and then briefs began to flow, or were you just given a brief and you had to find your way in that area?
It is rather curious. As a ranked junior, I did a lot of noting of judgments for a particular attorney who was versed in the intellectual field and took pity on me, thinking that he cannot only use me for noting judgments. And then I started getting briefs. In those days, the Patents Act provided for only 16 years, but you could get an extension under certain circumstances of 5 years. And that's where I really started, is to do the applications for extension of term. And then slowly I moved up.
Publications or applications?
Applications for...
So anybody can start in that area as long as you have work that compels you to familiarize yourself with that line of law.
Yes, I know of colleagues who have done the LLM course and not getting one brief in that. It is really by chance, that speaking for myself, that I landed in that field.
But by chance and by connections?
I wouldn't say connections, no.
Okay.
It's just because the attorney thought he was a real gentleman, and he thought maybe he should not be unkind and give me something better than you just know.
I'm sorry, I interrupted you. Have you finished?
Yes, I finished. Thank you very much.
Apart from intellectual property, what are the line? I'm trying to establish how the court could benefit from your experience should you be appointed. Yes. Apart from that?
Apart from that, I did commercial work, contract, etc. The issue of the intellectual property is not something that takes you out of the field.
Sure.
Everything remains the same, cross-examining experts, leading their evidence. It's just perhaps the application of specific principles to the field that deal with that.
Yes. And just in passing, what could be done to incentivize more black lawyers, women, not only to be members of the bar, but to also help them stay at the bar, help them stay on as attorneys?
That is a vexed question. In a sense, it depends on the individual, what he wants to make of it. But from the senior people involved in the bar, there should be, and there should be a more outreach to them in that regard, to get involved and to mentor them to not falter if times get tough, because at the bar you seem to go through various cycles. You a ranked junior, and then that type of work falls away. You get into the junior work, and then it's like a curve. You know, you go up and down, and it is to just persevere. I think the greatest drawback is financial aid. It's become very expensive to hold chambers, especially in view of the fact that
I asked the question because I know that colleagues that I studied with at the bar who were white did not all have rich parents.
Yes.
And unlike their black counterparts, they never were without meaningful briefs, suggesting that maybe as seniors have more work to release to juniors, the possibility of considering everybody might just help strengthen the possibility of everybody staying on.
yes,
What are the measures that the bar is considering apart from this? Is it financial assistance that is at the Pretoria Bar? What measures in terms of work distribution are being considered?
I'm not on the Bar Council.
Yes, sure.
And for that, it is difficult to really say what happens in the inner circles. From my part, I would encourage that there is, in the various areas, whether it's intellectual property, whether it's tax, or other commercial matters, is that juniors indicate their area of interest, and that there is like a pool created wherefrom you can draw juniors and in that way expose them to the particular field. And that is something that I believe can and should be done.
Without going into specifics, is it fair to assume that you've played your part
Yes.
in ensuring that the desirable objective that I suggested ought to be realized, or we should try to realize, is realized or realizable?
I would agree with that.
Okay. JP?
Thank you very much, Chief Justice. Advocate van der
Before I
Westhuizen.
forget, what is this fencing association? Because I could only think of a fence. I said, why is the advocate fencing now? What is he fencing? Is it a game or what? Is it sport?
It is sport, yes. It's
I'm a rural person.
But as a rural person, you would have had your fights with your siblings with sticks, etc. It is just, it's a modernized.
It's a modernized stick fight.
It's a modernized stick fighting, exactly.
Okay. All right. JP?
Thank you very much, Chief Justice. Good morning, Advocate van der
Morning,
Westhuizen.
Judge President.
I just want to go through what you've done as an acting judge. My spreadsheet suggests you've done 26 weeks, starting last year.
Yes.
And in that 26 weeks, you've done a third court. You've done the third court. I don't know how many you had that week. Did you have one or two?
One specific one that was quite lengthy.
Right. And then you had two special civil trials. How long were each of them? These are trials of long duration, isn't
Yes.
it? Yes.
I think the one was close on to 2 weeks, and the other one was about 7 days.
Now, then you've done 5 weeks in the opposed motion. and 5 weeks in the unopposed motion. These are work areas that you, especially opposed and unopposed, and in the agent court, that you deal with in your normal practice as an advocate. Am I correct?
That's correct, yes.
Right. Now, and when I look at the judgments you've handed down, the norm is you hand down judgments within a month to 2. But I think there's one where it took you just over 2.5 months to 3 months, which was a special review, the Ndaba one. I think it's number 41 in your list. And then there are 2 others, but they were all less than 3 months. Is there any particular reason why those took longer than the norm?
The one that took the longest was heard, I think, a week before the end of term. It dealt with constitutional issues. When recess started, I contracted the horrible flu virus, which took me out for about 5 weeks. But in that time, I still considered the judgment, not necessarily sitting with it. You mull over it, and that's how I approach my briefs and even the judgments. You don't just sit down and write the judgment, especially if it is something of some concern or importance. And that mainly, I think, was the issue.
Yeah. Thanks for that response. Let me just deal with an issue the CJ raised with you. In the special civil trial role, that's where I enroll the intellectual property matters in Pretoria. And they are only heard in Pretoria.
Yes, that's correct.
Unless I'm mistaken, one of those special civil trials was one such matter, unless I'm mistaken. The special civil trials you did.
No, that was not, it was medical negligence
Medical
was
negligence,
the one.
yes.
Offhand, I can't remember what the other one was.
But the point I'm making is I was not rebuked, but called to order by the SCA in a separate letter where one of the justices wrote to me and say I must stop fielding judges in work areas they know nothing about, because they had sat in an appeal where I put a black judge in the tax court, and the rest is history. I'm mentioning intellectual property deliberately. I'm not aware if there is any black counsel who does that kind of work. Am I wrong?
Not senior counsel, which is unfortunate. There are some juniors that have been used. I've had one specific one that I've been briefed with in 2 matters. That was a trademark matter, great assistance. There seems to be, in respect of patents, a hesitancy because it is something strange to maybe the culture. I've approached a lot of black juniors and even female to assist, and when they hear it's a chemical matter, they sort of stand back, which when I was briefed in one, I was also aghast because I had a very brief school exposure to chemistry, etc. But it is something that can be gained by way of experience, and but there is an interest in that. Yes. It's unfortunate that there are no seniors. There was one particular candidate attorney that became a director at one of the big firms, and he had shown great promise had he gone to the bar, but he was appointed or elevated elsewhere, also in the intellectual property area.
Yeah. I think I raise it for one simple reason, that I think it's a constitutional injunction when it talks about demographics, that our jurisprudence should also reflect that.
Yes, that is correct.
You agree with that?
I agree fully with that.
Yeah. Because it can't be right that in any intellectual property matter I've got to put white male judges. Well, I have one female judge, yeah, but she's also white.
Yes.
Yeah.
It is very unfortunate, and that is something that had concerned me and some of my other colleagues to a great extent, but it It also depends on the individual, whether he would stick out his neck, so to
Yes.
say.
And when you're a silk, I'm sure you've had matters where you've been the lead counsel.
Yes.
It's your choice which junior you pick. I think the bar councils are now changing that rule.
They are
But
changing it slowly.
It's been
yes.
your choice as leader which junior you want to bring. This just touched on something else, the other side of the coin. I had a meeting with a very senior official of a banking institution to ask him why matters from his bank never landed in black hands. And he said, no, it's the attorneys they brief who prefer to brief white counsel. I found it strange because if he says, I'm the client, I want you to brief black people, why would the attorneys do so? But is that a phenomenon you can talk about, that the firms are the
Yes,
ones who call the shot about where the briefs go?
I would say up until about 3-4 years ago, that was the norm. They did not want to use inexperienced counsel in that regard. That's why there's a very close community
Yes.
of advocates that do the intellectual property, which is sad. But that seems to have, some of the firms have been broken
Yes.
that sort of steadfast rule, where they are in fact searching and encouraging.
Okay. No, thank you very much, Chief Justice. I've got no further questions.
Thank you. Before I forget, just two things. The reluctance to be involved in matters or a case involving chemicals by Junior Black and culture, how do they come together?
That may be a wrong perception on my part, but it's even under the young white counsel that are hesitant because it seems very daunting to do with chemistry, etc. But when one is in practice, it very much or very little turns on the chemistry. It's for the experts to explain, and then it's merely just to apply the principles. My perception may be wrong, and I hope it is wrong, that it is culture. When I say culture, in the sense that many young black counsel come from the rural areas where they had normal schooling, not necessarily.
But they are taught chemistry there.
Sorry?
I was taught chemistry in a rural
Yes. No, that is so.
in a rural school where the acting deputy chief justice stays. Where does the perception come from that rural people
No,
or
I don't
black
say it's
people-
rural.
or black people would be disinclined to have something to do with chemistry?
The way I may have expressed myself, I did not say it's only from the rural areas. I said it was also in respect of white counsel that
So
there's a
it's
hesitance.
culture that cuts across.
Cuts across everything.
Then it's not culture. Culture can't be the basis for the disinclination to
No,
be
no, no.
involved if it applies to both blacks and whites.
You're quite correct, Chief Justice.
All right.
That is
So it was just an error.
yes.
Okay. Now, the JP asked you about why either clients or attorneys would not be keen to have black junior counsel involved. And then you say, they don't want to use inexperienced counsel. What does that mean? Or black inexperience, what does it mean?
Inexperience in the sense is that where there is already a pool of juniors that are active in the intellectual property area, they tend to use that pool and they don't fill it on. And in that sense, I use the word inexperience. not being exposed to the particular area, not necessarily intellectual property, but other fields of law too.
I'm raising it because it sort of almost became controversial on a wide scale, this thing of robing in black counsel and inexperience. So I don't want you to live here with an unfair perception about your views attached to you. Is it fair to assume that everybody comes to the bar with, well, not everybody, many people come to the bar with limited experience?
That's indeed true.
Black and white.
That was my circumstances too.
And has it been your observation that some of the white counsel, junior, get the work which some black juniors are actually more experienced about than they are?
Yes, I have to agree with that.
So inexperience cuts across.
It cuts across, yes.
Okay.
But I use the word inexperience in the sense is that where there's an established pool, there it appears to be, or appeared to be until 3-4 years ago, that they did not want to go outside that pool, which was in that sense, inexperience.
But it is the same in every area of
In
the
every
law.
area, yes.
Whether it's criminal law or divorce, you hardly ever come across a situation where there is keenness, either from client or from their attorney, to brief black junior or senior practitioners. Is that not your experience?
That is...
Yes. That is why the attrition rate really is to be found primarily, if not exclusively, among black practitioners. They are the ones who fall out of the profession because they're not getting enough work.
Yes.
Not because they are not any good, but just like Langa, your Mahomet, your Museneke, your Ngobo, however good you may be, you'll just never get that work.
Yes. That's why I propose that there should be a pool where people, counsel of any creed or culture, should indicate their interest,
Yes.
and that from that pool,
Yes.
there is a concerted effort to get such juniors on.
I thought I should clear that up before commissioners raise difficult questions with you.
Thank you very much.
Commissioner Lusufi, I'm sorry, MEC.
Thank you so much, Honorable Chair. Yeah, that's fine. Good morning, Advocate.
Good morning.
Just take me through your understanding. For you to understand laws are just or unjust, is it through education or training, or is it through knowledge in terms of general knowledge or reading from newspapers? Just for you to understand if laws are just or unjust.
A bit of both, I would say. It's your life experience and also the particular areas where you...
So by 1992, after you've qualified with your LLB, you had an understanding of laws being just and laws that are unjust.
Yes.
So when you went to join the army, you were enforcing an unjust system.
I would not say it was enforcing a judge system. The situation was that if you refused to do the conscription, you were treated as a criminal. You had to waste time for 4 years before you could get into society and in your area of specialization or your area of education to do something about that and to assist the people who are not there. It is in that sense, had I followed the other way of being adverse, it would have tarnished my ability to be able to assist later, which when I had the opportunity to do so, I in fact did so.
So you went there knowing that apartheid was an unjust system.
Yes. It was something that I could never understand as a kid and even later, and
But
still do not understand that.
But I went through everything that you've given us there. There's no single indication of you opposing it.
As I've explained, that the opposition is not necessarily from the outside, it can even be from the inside. But I am a very apolitical person in a sense. For me, it deals with justice for all, and everyone has to be either represented or assisted in having the sun shine on him too. And that can be done from without or from within a particular situation.
So apartheid needed to be opposed only by political people, not our political people.
No, that's not what I said.
I'm saying you said it was an unjust system. I'm going through your records. You've never raised your finger on anything that is related to apartheid. Am I correct?
But in the papers that I've filed, no.
Okay, outside these papers?
I'm a private person. I do what I do. I've never joined any group for various reasons. The main reason being that being an individual is as good in opposing or supporting whatever. But in my papers, I have not indicated anything.
I'm trying to find your suitability in representing everyone. Because from your records, including your sport, fencing, and any other thing, it's a privileged background. And you are requesting us to consider you to represent and serve everyone. But in all the documents that I have in front of me, there's no single indication that you know what is an informal settlement, you have visited an informal settlement or worked with people that are outside your background. Everything that is here is a one-sided view of how society it is. Our society is.
I would not agree. In fencing particular, there is a concerted effort from the various provinces and clubs to assist candidates or potential competitors from the previously disadvantaged groups. Where I was at North Gauteng, we still have the Mamelodi Fencing Club, and its protege was for many years the South African champion épée fencer. We supported, and I personally, out of my own pocket, bought fencing equipment to assist them in their training, the young lads. It's in that sense, it's not just for privileged, it is also for the unprivileged. And there's a concerted effort all along to assist and to get.
But let's agree, fencing is a very expensive sport. It's very expensive, I know it. And if you said you supported somebody, it's fine. But did you play fencing in Mamelodi? Did you go to Mamelodi and play fencing?
No, I did it on a social basis. I never participated in competitions. As the vice president and as the president of the North Gauteng Fencing Union, we had, and I personally had many discussions with the person from Mamelodi. We had at one stage tried to, and in fact it was done, arranging competitions in Mamelodi. But the fencing community, although it's correct, it is an expensive sport, but specific arrangements financially are afforded to assist the potential sportsmen in realizing their dreams. There's many financial issues which would allow and permit them to compete at competitions throughout the country, because it's done in various centers, and they are financially assisted.
I'm about to conclude, Honorable Chair. I just want to get this clarity. As a potential judge, will you implement unjust laws?
No.
But you said...
Within sorry, if I may just qualify my no. No, within the Constitution, one has to consider whether the law is just or unjust, and on that basis, if it is found to be unjust, one refers it to the Constitutional Court to deal with it finally.
My initial discussions with you was that you either qualify or get knowledge of implementing something that is unjust, or is through general knowledge. You said it's a little bit of both, that you can do that. And I'm asking you now, and you are doing qualification to say it must be within the Constitution, but previously you said you didn't want your image to be tarnished. That is why you went to defend an unjust system.
It's perhaps not the correct perception that I have come across. What I had said is that you can, from within, deal with things that are unjust, and not necessarily only from the outside. And it's not really a question, sorry, my apologies, it is not a question of protecting my image. I've never been a person that would be arrogant to protect my image at all costs.
And MEC, maybe before you, just in case you're going to follow up, his response was he didn't want to spoil his prospects. And that's where he used the word image, of furthering his studies or pursuing his career by being a conscientious objector.
Point taken, Honorable Chief Justice. My last question, in which year did you start to realize that apartheid was wrong?
I said earlier, when I was young, it was...
In which year? I'm asking. Yeah, specifically.
A year. Well, I can remember of my childhood, it would have been from about when I was 5 years old and on, visiting my grandparents in New Bethesda, that small town in the Karoo. My experience was that the people seemed to be accommodating to one another without having to deal with certain issues, but certain things and events came to mind which seemed unjust and not correct. And that would make me 9 years old. Probably, no, 9 years, 5 years on from 65, about 61, 62, around in that area. But it's difficult to put a year to it. It just seemed wrong.
Since 9 years old up until now, you have never raised a finger against racism or participated in any structure or defended anything that is related to non-racialism. Am I correct?
In my papers, yes. There's nothing there.
Thank you so much. Thank you.
Thank you, MEC. Commissioner Malema.
Thank you very much. For sure you know that we all write our own history, right? As we grow up, everything else we do, we are writing our own history.
Partly. Circumstances also writes your history. Not only yourself, but circumstances also dictate.
Through our own conduct and the things that we engage in, it doesn't matter the circumstances. We're writing our own history.
As I said, to an extent, yes.
And we'll be judged through that history.
But the history is to be seen within particular circumstances.
We agree with that, but we'll be judged through that history.
Yes, I've said that.
What is the longest time? Time, I mean hours, minutes, seconds, The longest time you have spent in a township, black township, in Mamelodi, Atteridgeville, anything, Soshanguve, the longest, where you are so relaxed and, you know.
Time-wise, I can't tell you, but
No, but you can
been there.
estimate.
Couple of hours.
Eh?
Couple of hours.
You must help us to help you. We're going to appoint you. So once you tell us nice answers, then you're going to be a judge. But if we go like that, you're not going to be a judge, I can guarantee you. So how many, just give me an estimate, the longest time you have spent in a black township.
Commissioner, it's difficult to say. I don't watch time. Could be half a day, it could be 3/4 of a day, it could be a day, I can't tell you. I don't time myself in respect of any attendance wherever it is. I do what I do.
That's your answer. What is racism?
Racism is denying somebody not of the same creed or culture as yourself any.
How do you become a racist?
How do you become a racist?
How do you become a racist?
Probably by choice.
You just choose to be a racist.
Yes.
You are not taught to be a racist.
No.
Can racism be a culture, a part of upbringing?
No. Because each one is an individual and has to decide and fend for himself. He knows what is right and he knows what is wrong. So it is by choice, not by...
No, but the
culture.
apartheid taught white people to be racist in schools through propaganda and the type of education system they imparted on those people. They taught them to be racist.
The teachings might have been there, but the individual, it's for him to decide whether he would follow and whether he agrees with that teachings, that doctrine.
But we agree that apartheid taught white people to be racist. It was part of the system. It was part of the education system. That's why there was Bantu education and education for white people. They were taught to hate.
I would not say he were taught to hate because, again, as I said, it's for the individual to decide whether he hates somebody or not.
Apartheid did not teach white people to hate black people. Is that what you are saying?
There was a doctrine, but it's not necessarily that everyone accepts the doctrine.
Did apartheid teach white people to hate black people?
I've given my answer.
But I'm asking a question. Did apartheid teach? It doesn't matter whether individuals decide to choose to accept the teachings or not. Did apartheid teach white people to hate black people?
No.
Apartheid didn't teach
Because
them.
there were many people that I knew as a child that did not hate people from the other color.
Apartheid taught white people to love black people. Is that what you are saying to me? That's why it was so nice, apartheid. That's why you joined the army.
No, that's not what I'd said. I'd said what I'd said. I've answered your question.
Was the apartheid system not declared crime against humanity by the UN?
Yes.
Because it was a system that perpetuated hatred of black people by white people.
Some may have followed the doctrine, others did
Not whether others followed or not, the system itself. Slovo didn't follow the system. Ronnie Casares didn't follow the system. There are many white people who didn't follow the system. That's not what I'm asking. What I'm asking is, was the system designed to hate black people?
Before he answers, Commissioner, remember my plea yesterday about lowering the voice? Just the question will still be impactful. Please provide the answer, sir.
I have not made a study of the apartheid system, but I accept that it could be that the main doctrine was, or the main thought behind it may have been, I don't know, to hate others. What I've known of the apartheid system was that people were separated.
Will I be correct to describe you as a defender of apartheid through those answers you have been giving me?
No,
No, you are. You are defending apartheid.
I'm not defending apartheid.
And you are in denial that apartheid taught white people to hate black people. And others realized this was an evil system and they rejected it, even though it taught them to hate. That's why Madiba says no one is born a hater. They are taught to hate.
That may be one way of looking at it. I'm not defending apartheid. It's indefensible. And I explained earlier to other commissioners' questions that it was something that irked me. I did not understand.
But
the reason.
apartheid taught to hate.
If that is the perception, yes.
No, but I want your understanding. Did the system of apartheid teach white people to hate black people?
If that was the intention, did not succeed. Because there were many people, not necessarily the exponents that you had mentioned, that did not follow that.
Are you a racist?
No,
Can you speak any African language?
no. I'm a lawyer, not a linguist.
So you don't see any need of learning African language because you are not a linguist. I'm a linguist, but I know colonial languages imposed on me by the apartheid regime. The system you benefited from.
I would not say that I had benefited from the system. Nothing had come easy. I had to battle to reach where I am today. I did not benefit from anybody or any organization. There are official interpreters. If judges were to be, in addition, linguists, it would do away with employment, which is necessary, and there should be a drive to appoint more dedicated interpreters.
Are you an advocate with
Yes, I'm an advocate.
with a firm?
No, I'm on my own.
You're on your own.
Yes, advocates practice on their own, not in firms.
Go on your own with your firm. Good luck.
Minister?
Good morning, sir. Is it still the morning?
Good morning.
I will simply put it to you without pursuing the matter any further, following on the questions that you've answered so far, that you are in a state of denial.
No, that's not the...
Can I just finish the point?
My
and you
apologies.
and you can react. That you are in a state of denial about a reality that is not only characteristic of a historical past, a painful historical past that this country went through, but which it is still grappling with, and that because of that, you do not present yourself as somebody who's poised to aid the transition that the Constitution envisages in South Africa from a past, the inenviable past, to a future that this Constitution cherishes. Would you consider that an unfair assessment of yourself by myself, based on the responses you've given this morning?
Yes, I would say that it is unfair. If the perception is that I'm in a state in denial, that is unfortunate. Insofar as apartheid did teach people to hate, that I accept. But what I say...
Commissioners, please.
I'm still on the floor.
Please.
What I had said is that there was the doctrine, which I never understood, never agreed with, but despite the doctrine, people accepted one another and did not hate. To the extent that the perception may have been created by my answers, that I endorsed it or that I'm defending it. I am saddened by that. It is indefensible. And I accept that the doctrine was there to prevent white people from fairly and openly associating with all other creeds. And that is deplorable.
I'm going to step off that point and leave it for what it is in the light of the responses you've given so far on the questions raised. But I want to narrow it before I leave it to the specific area of the legal profession. Do you believe or do you not believe that racism or racial exclusion or marginalization continues to bedevil the legal profession such that past privilege continues to perpetuate and past exclusion based on race and gender also continue to perpetuate opposite each other?
Yes, I agree with that. It still continues, and it's something that one has to work to get rid of. It will take time.
Would you agree that this is a system that was planted by apartheid? It was but one of the many frontiers of the system of apartheid, which continues to resist eradication despite a constitutional order that we have adopted since 1994.
I have to agree. I cannot not deny that it is a reality we have which has to be addressed.
And being apolitical as you have described yourself, have you done anything, or do you believe you have any responsibility to do anything to correct this as a member of that profession, given your acknowledgement thereof?
Yes, I have, as I've indicated in my papers, mentored, and as far as I'm able to mentor many black colleagues and female colleagues to assist them in reaching that which I had reached and even to surpass me. And I believe that is something that is a continual endeavor on my part.
My final area that I want to engage you on, you would accept that the mainstream of our legal system, especially your private law or civil law area, is largely based on Roman Dutch law, or common law as it's called, because of historical reasons that we have just described. Do you believe that post-1994 the time has come for that mainstream system to be transformed in a manner that it begins to infuse the values and principles deriving elsewhere other than Roman Dutch law, specifically indigenous law, for example?
Indeed, so one of the judgments that I delivered dealt with that very issue, where the approach in respect of support was to follow the customary law, where there's an obligation on children to support their parents. And I acknowledge that, and I still acknowledge that there
Was
are many
that in
areas.
was that in respect of a mainstream legal dispute, or was it in respect of a dispute arising purely out of the application of a African customary law situation?
I would have liked it to be a mainstream, because that's where one starts off, and not necessarily just to a particular area. There should be more, and if I'm granted the opportunity of expanding and the law in that regard, I would gladly do so, to draw in the customary law, the African law, and the approach to that.
Thank you, Chief Justice. Acting.
Thank you, Minister. Commissioner, did you?
Thank you very much, Chairperson. Good morning, sir.
Good morning.
How are you?
I was fairly well until I came in, yeah?
We agree.
I understand. Looking at your specialization in terms of the field of law that you said is your interest, what contribution have you made in the legal profession besides your practice? Have you thought of writing any book or whatever? Or journal, article?
There was occasion that I thought I would do or should do something to that extent. However, I am not a writer. I write judgments when I act, and I write opinions, etc. But I'm not that talented to be able to write the article. I've never tried. Maybe I should have, but I haven't.
Thank you very much. Given the importance of the intellectual property, maybe just to tease your views in respect of the EU-South African trade agreement, there was a time at which the European Union were very adamant that South African agricultural industry must actually stop using particular names based on their law of geographic indications that related to champagne, ouzo, and grappa. And I think as a country, that's my view, we were found wanting in finding a better way of defending ourselves and ensuring that we protect those trademarks that we have had and used over the years. But because Europe decided to have, decide and have a law on geographic indications, we lost it, and it took time for the industry to adjust. What would you have advised if you were consulted during that period?
I am very much for the underdog, and I would have advised that we should have not allowed ourselves to be bullied by Europe or any other foreign authority. The same really applies to our trademarks, such as rooibos, etc., that we should have come out much stronger. I think jurisdictions are jealous of what they have, and they seek to protect that. But it is something that we may have dealt with sooner rather than later, and more, in quotes, aggressive, unquote.
Through you, Chair, if I were to just pursue it a bit, given that as a country we're part of the global system and part of the World Trade Organization, and some of those instruments are not necessarily dependent on whether you want to protect or not. That's why I was asking for a legal view. I hear you said countries should have defended, but legally, and in terms of the intellectual property law, is there anything going forward that a country can do, particularly where you have to enter into trade arrangements?
That's a tough question. I would advise that each jurisdiction is entitled to its protection it has in various areas, but that there should be an agreement that certain well-known areas over many years should not be jealously protected, but should be shared.
Just the last question. Do you think in terms of law, indigenous knowledge can be protected? Which is knowledge that has been passed from generation to the other?
Yes.
Could there be a legal framework that could be developed to ensure that such protection is legally binding?
I would agree to that, in that what is one's own, you should be protected. And in that sense, I would say there should be, times have changed. We are in a modern time frame, and there should be acknowledgements towards, in particular, the African knowledge in that regard.
Through you, Chair, just a little follow-up on that one. Oh, CJ.
On the legal advice.
No, not on the legal advice. We're talking on the indigenous knowledge system. In mind, I've just thought of the case of Hudia and the San and the Khoi people. This was a medicinal plant that they know they have used over the years, its properties, what it does, and so on. But when that got commercialized by pharmaceutical, a challenge emerged. That's why I was raising the issue of indigenous knowledge systems as to whether there could be a legal framework of how that is protected. Because they gave their knowledge freely when research was done on the plant. And Hudia now is a very commercial, medicinal, drug. And I don't think there was anything much that the Khoi and the San people would, gained as a result of that knowledge. And it was in that context that I was asking, particularly given your field of law, that can there be anything that can be done in order to protect indigenous knowledge?
There has been an amendment to the Patents Act in that regard, which may not go far enough, but there should be some other acknowledgement, and I would say financial at least, when you use that type of information, and not exclude where you get it from. I was involved in the Viagra matter years ago, before that became settled, and it also appeared in that matter that much was borrowed from information gathered from the traditional African usage.
Commissioner Semenya.
Chief Justice, thank you. Advocate Van Westhuizen, good morning to you. Oh,
Morning.
Midday.
Good afternoon.
I would like to discuss with you one of your judgments. it is not one of those listed in your application. Is the judgment in the South African Diamond Producers Organization versus the Minister of Minerals and Energy and others. This is a matter where you struck down a section of a statute as being unconstitutional. Do you recall that?
Yes, I recall that.
Now, obviously, I don't want to discuss with you the correctness or otherwise of the judgment. That's not my area of interest for this interview. In that judgment, and this is my inquiry with you, in that judgment, you made a finding in contradiction to a finding done by the Supreme Court of Appeal on the same aspect. Now, what I want to ask you is, what are the juridical guidelines that inform circumstances in which lower courts are to differ with findings of the superior courts?
I recall that was the point that you appeared before me in that matter and you argued. In the SCA judgment, certain information was provided in the application on which the SCA had made the ruling. I differed from that ruling on the basis as to the facts that were before me, which were far more. There was a specific letter that had to be interpreted. The letter was not before the Supreme Court of Appeal, and the submissions or the factual allegations in that regard were contrary to what was stated in the letter. Having the letter before me and having heard the argument from both sides, I had not followed the SCA's finding. Had the SCA had all those facts, the ruling may have been different. And it's on that basis that I had differed from the ruling. I had more facts before me than the SCA.
No, that's why I'm not asking about the case in particular. I'm just trying to establish, juridically speaking, what are the guidelines that must inform a lower court departing from a finding by a higher court? What are those signposts?
If there's a clear indication that the higher court, whether it's the SCA, whether it's a full bench, was not correct in their finding, it's in that basis that you can disagree. It's difficult. You are bound in terms of the stare decisis rule to a higher court finding. But if it appears that there is other issues that would have influenced that, one can.
I understood stare decisis to mean even if the higher court is wrong, as a lower court you're bound by that, no?
Yes, you are bound, but if in the particular case the facts are different to what was before the one, then to extrapolate from that and to find yourself bound by that.
Okay. Your understanding of judicial deference in constitutional law, what did you say it is?
Pardon, Commissioner?
The principle of judicial deference in constitutional law, what would you say that is?
The Constitution is first and foremost. It sets principles, guidelines that are to be followed when dispensing justice. It establishes various tiers of courts, and there is to be appliance of the principles in that regard. The Constitution is first and foremost to be fair to everyone.
Is that your answer?
The further issue is that you have the three tiers. You have your legislature, you have your executive, and you have your judiciary. To borrow from mythology, ancient mythology, it is akin to Cerberus, the three-headed dog that protected the entrance to and from the underworld. The one head being the executive, the other head being the legislator, and the center head is that of the judiciary or justice, that separate the two from impinging upon one another or one another's fields or areas without devouring either or both, and upholding the Constitution within which the courts are to be or to work.
Under our Constitution, are there areas in which courts can't go?
Can't go, yes. Particularly where government has set, the word escapes me now, but set policy. It's not for courts to adjudicate upon the policy, but it is for considering laws that, in terms of the Constitution, may be found to be against the Constitution's protection.
Chief Justice, thank you.
Thank you, Commissioner Semenya. Commissioner Nokesi.
Thank you, Chief Justice. Counsel, I will just ask you on your judgment, this of Valituba,
Yes.
the judgment that you have attached. I just want
That's the criminal judgment.
the
where-
criminal
yes.
judgment. In fact, just before that, I note from the spreadsheet that you haven't done any criminal court during your acting period.
The allocation of matters and courts that acting judges presiding are the prerogative of the judge president.
Yes.
And if he requires a judge to deal in a specific matter, it's his prerogative. According to, and in terms of my questionnaire that I submitted, when I started at the bar, I did many criminal matters for a long time, and that was my main intention until I was channeled a different direction. But I have sat on appeals, special reviews, and it's very much a question of determining the facts and then applying the legal principles.
Thank you. In this judgment, you increase the sentence from 10 years to 15 years sitting as that appeal court. You increase the sentence from 10 years to 15 years. Obviously, you, in the course of that judgment, you pay heed to the judgment of the Constitutional Court that before you increase a sentence, there must be some form of notification to the appellant. You noted that?
Yes.
And my understanding of this judgment is that you purely, as I read through, you purely rely on the seriousness of the offense when increasing that sentence, despite the concessions made by the state in relation to the sentence itself, that it was, of 10 years, that it was not shocking. But my question is simply this: what are the factors that the court should take into account when passing a sentence in circumstances of an appeal like this one?
In that matter, the appeal was before a previous court who indicated that there should be submissions as to why the sentence should not be increased. Neither of the parties had heeded to that request. The only issues that were raised, if I recall, were the issues relating to the personal circumstances. Nothing else was raised. And there is authority, which I did refer to, that is not the only factors in dealing with it. If the perception from reading the judgment is that it was purely as to the gravity of the offense, that is not correct. It also dealt with the factors that were absent in having the minimum sentence of 15 years for a first offender imposed. It's on the accused to set such factors before the court.
Thank you very much. I won't take the matter any further. Thank you, Chief.
Thank you, Commissioner. Commissioner Nyambi.
Thank you, CJ. Afternoon.
Afternoon.
The first question is about the issue of the Constitution from the first page. The preamble of the Constitution of South Africa, if I can quote it, say, "We, the people of South Africa, recognize the injustice of the past, honor those who suffer for justice and freedom in our land." If you can share with us your understanding of that.
My understanding of that is that prior to the Constitution and prior to the time of which we enjoy democracy, as it was not acknowledged prior to the Constitution, that the Constitution is to uphold each and every one as being equal and not to be subjected to the past injustices, which would primarily be the doctrine of apartheid. And it is for us to uphold that principle, that all is equal. All are equal, rather.
Because you won't be privy to the deliberations, maybe the issue of the language, when you ask whether are you able to speak any African language, what was your response?
My response was that I am not a linguist. I do not speak any of the African languages. I do not have an aptitude for languages. That's why I'm not a linguist. I'm first and foremost a lawyer that is to uphold the Constitution, that there is fairness to all and justice to all.
What is a linguist?
A linguist is a person that does the study of languages.
How can language, race, and gender legitimize confidence in the judicial with your own understanding?
The situation we have in South Africa, it's a multicultural, multilingual, multi-religion, multi-everything. And not all are able to speak all languages or to learn it easily. And that should also be accepted. And sitting as a judge, there are various issues. Language being a difficult creature, much can go lost if you are not 100% schooled or experienced in a language. Even from Afrikaans to English, there are many nuances that get lost if you are not 100% fluent in that language, or either of the two. And as a judge, you have interpreters that could interpret that nuance, which you may have not picked up because you are not 100% schooled in, say, a particular language.
Thank you, CJ.
Thank you, Commissioner Nyambi. Commissioner Nkosi Thomas.
Thank you, Chief Justice, and good day to you.
Good day.
I just want to follow up, please, on your answer, the answer that you gave to a question by Commissioner Didiza. And you said that you are for the underdog. And as South Africa, we should not allow ourselves to be bullied by Europe.
Yes.
Now, in that answer of yours, I take it that Europe would feature there. In that example, as an investor in South Africa would be a host state in the context of an international trade investment deal. Is that right?
Yes.
Now, there's this global tension that I just want to test to find out what your thinking is around that, as between host states, such as South Africa in your example, and investors such as Europe in that example. And that tension is between, on the one hand, the investor seeking to extract as much profit as possible, return on their investment. That is on the one hand. And on the other hand, the sovereignty of the host state. And I just want to find out from you how that tension could be balanced out. And that has seen South Africa terminate most of its BITs, bilateral investment treaties, because of that tension. So my question is to you, in the context of you being for the underdog in such a scenario, where do you see the solution in that situation? How could we possibly resolve that tension?
That, in a sense, has bearing on perhaps closer to political views and strategies, commercial views and strategies, all need to be married, if I may use that word, and to find the balance. It will be a fine balance, but it would be a great challenge to be able to achieve the fine balance between the two. And it is perhaps more on the field of people in commerce, in the political arena, to really dedicate or to define the approach in that regard, other than from a lawyer.
Thank you. Do you think the passing of the Protection of Investment Act would assist in that regard? You know, the act that has just gone through Parliament on the Protection of Investment, the Protection of Investment Act, I think that's what it's called. Do you think that will go a long way in harmonizing that space, the tension?
I must concede that I do not have intimate knowledge of that, but it would seem that it is a step forward, if I can put it that way.
Thank you. Thanks, Chief Justice.
Thank you, Commissioner. You are excused, Advocate van der West.
Thank you very much,
Thank
Chief
you very
Justice.
much.
Thank you very much.